Someone's here for the AG. And Miss Leno.
Good morning, Your Honor.
Good morning. I saw your name throughout the transcript.
And I'm here in an unusual capacity for me. I'm not here as the attorney. I'm here as the client representative of the State Athletic Commission.
You know what? Somehow I thought you might be. I don't know why.
And we welcome her, Your Honor.
Absolutely. I always welcome Miss Leno.
It's good to see you in your new courtroom.
I got a big one. Thank you. I appreciate it. Okay.
Good morning, Your Honor. Vivian Markowski from the Attorney General's Office.
Okay. Thank you.
Nevada State Athletic Commission.
Okay.
Good morning, Your Honor. Christopher Eccles on behalf of the Commission.
Okay. All right. I reviewed everything, but I would welcome argument. There's, as you know, two big issues. I'm looking at the jurisdiction and also the sanction that was done. I have literally pieced together every statute I can, you know, to do it and look through the record that is there. And so, Mr. Goodman, you, since it's your motion, your petition, excuse me, for judicial review, I'm so used to motions, if you want to start out.
Thank you, Your Honor. Would it be okay if I take the
Absolutely.
podium?
Come to the podium
Okay.
now. Get a new pen. Okay.
As the court has already indicated, the big issue here is one of law, which the court reviews de novo. And it's a jurisdictional issue, and it's an issue that our position is that could it be more clear, it's crystal clear. And in effect, we're appealing the fact that this Nevada State Administrative Agency wants to be the only agency in Nevada or the country that believes that they should have jurisdiction over somebody not licensed by the agency. That would turn administrative agency law upside down on its face. As the court knows, and as we cited in our papers, agencies are a creature of statute. You're limited to exercise the jurisdiction that the legislature conferred on you. No more, no less. If they wish to or attempt to want to expand this drug testing policy to people who are not licensed by the agency, they could do that. They could play within the rules and the law, put everybody on notice and go to the legislature and say, you know what, we have this new drug testing policy, we need to expand our jurisdiction, and they would have to figure out a way, or at least a statutory way, in order to go to somebody, ask them to submit to a non-consensual blood test or chemical test who hasn't provided consent, who's not licensed by the agency, but they haven't done that. And so they have to play by the rules and play by the statutes. And as the court already indicated, the statutes clearly show that you cannot require somebody to submit to a chemical test, much less discipline them, take any type of disciplinary action against somebody not licensed by the agency, because it directly contradicts the very statute that they're trying to hold Mr. Silva accountable under, and that is subsection 6, NAC 467.850. And I will not belabor the court. I'm sure the court has already reviewed that at length. But subsection 6 says, a licensee who violates any provision of this section is subject to disciplinary action by the commission. It cannot be any more clear and unambiguous than that. In order to violate somebody for a drug testing policy or a violation of 467.850, the legislature has mandated that that person be a licensee of the agency. Now, interesting enough, Your Honor, I'm not even sure why we're here. There was no need for us to be here. They omitted this jurisdictional statute from the initial complaint. They have failed to recognize that throughout the entire proceedings before the commission. They took short shrift of it by, when I filed a motion to point out the clear and obvious jurisdictional defect, there was no deliberation among the commission. In fact, the chairman of the commission went directly to Mr. Eccles almost as a oof, Mr. Eccles, and then Mr. Eccles responsibly said, no, Mr. Goodman, it's his motion, he has to argue it. So it was, and they weren't going to give any consideration to it. I made my argument. They made no response whatsoever except to summarily deny it. They did not explain why they thought that they could discipline somebody under NAC 467850 who's not licensed before the commission, even though it clearly and unambiguously says that you must be licensed by the commission. Now, in response to my motion to dismiss for lack of jurisdiction before the commission, for some reason the state then responded and said, well, wait a minute, we also think that the commission has statutory jurisdiction under two alternative statutes, which are NRS 467.110 and NRS 467.158. Now, I'm not sure why they tried to cure the obvious jurisdictional defect under 467.850 by pointing to these two statutes, which are under the heading licensing. And you don't have to go any further than NAC 467.992 subsection 1, which also mandates that the person be licensed. Specifically, it says, the executive director or a commissioner may institute disciplinary proceedings described in NRS 467.110 or 467.158 against a person who is licensed pursuant to this chapter by filing a complaint with the commission.
Could you read that again? I wrote it NAC 467.922. Oh, I put 9.
467.922
subsection 1. Okay, I put 9 down, and that's why I didn't find. Okay, I'm sorry.
And that's cited throughout the initial petition, Your Honor. Okay,
I just wrote it down wrong,
No
Mr. Goodman,
problem.
so I wasn't following my statutes. Okay, no problem. Okay, so you're saying that even references the word licensed to be able to do it, correct?
Correct.
Right.
So,
okay.
so first of all, the basic premise is that they want to, they being the commission, an administrative agency wants to discipline somebody who's not licensed by them. And I'll get to this later, Your Honor, and I believe in retaliation for Mr. Silva challenging the commission based on their lack of jurisdiction, they retaliated against Mr. Silva by not only still fighting against him, by the desperate treatment that we outlined in our petition regarding his sanctions.
The type of sanction.
Right, and I'll get to that in a second, but we don't even get there if this court finds that that this order directly contradicts with the licensing requirements under subsection 6 of NAC 467.850.
Okay.
Again, we're standing here almost in a vacuum because there was no response at the commission level hearing to this issue.
To the jurisdictional.
To the jurisdictional issue.
There was quite a bit on the sanction.
Right.
I read it. Okay.
It was just a summary denial with not so much as, well, we believe that we do have jurisdiction notwithstanding that. You will hear, Your Honor, and I think that I was very clear as I pointed out that in the answering brief filed by the state, they don't even address those statutes requiring licensure, that you have to be licensed as a prerequisite to have jurisdiction, for the commission to have jurisdiction. Instead, they basically, and you can look at their answering brief, and we cited to the page numbers, that they believe that they should have jurisdiction because they have this new drug testing policy, and if they actually complied with their statutory directives and followed the law, they would not be able to have this out-of-competition drug testing on people who were not licensed by them. So they believe that they should have that. And whether or not they should is not an issue before this court. It's really an issue for them to work out with the legislature so they can have that statutory power. Now, I would be remiss not to point out, Your Honor, that the state also violated NRAP 28 subsection E subsection 1 by certifying to this court that they only cited to matters within the record.
Right.
And remarkably, they produced in their answering brief for the first time hearsay articles outside of the record, despite Mr. Eccles certifying to this court, subject to sanctions, that everything that he relied upon in his answering brief was within the record on appeal. So we would ask that the court, our request is based on that violation, that the court make a ruling or strike those pleadings as fugitive documents in violation of the appellate rule. Now,
Well, I did put a thing down here. I did see that the court, there are references and arguments in the commission's answering brief which are not supported by the record on appeal. I did review that, and I understand that. Okay, that is an issue. I put that down as, I agree with you. I read the record on appeal. I saw it, which I'm limited to.
I don't want to belabor the point because it's cited to at length in my papers, but by violating these licensing statutes, and understanding that the basic law for administrative agencies is that they're a creature of statute, exceeding, and not only exceeding their jurisdiction, but they're violating the statutory jurisdiction that they have. If this court allowed it, would turn the administrative agency law upside down, and specifically with respect to the power, the limited powers that the legislature conferred on this commission to only discipline people who are licensed before the commission. Now, I just want to point out to this court, which I'm sure the court may note of, that the only real argument that they made was that they believe that subsection 5 of NAC 467.850 allows them jurisdiction to discipline somebody not licensed by the agency. And we already went through the fact that the subsection 6 says you can't. Says a licensee who violates any provision of this section is subject to disciplinary action by the commission. So if they're saying that they have jurisdiction in subsection 5, you have to go to subsection 6 saying, okay, we have to be licensed in order to find a violation of the statute. But I just wanted to distill for Your Honor, because it was kind of not that clear in the papers, how the court should look at the term unarmed combatant.
Unarmed combatant.
Yes.
If you could. The
Okay.
court had quite a struggle with unarmed combatant. I agree with you, but they used it back, not a struggle, but there's a lot of different terms used throughout these, and I would like, that was one of my questions.
So
It's also in NRS 467.158 when they talk about the preparation for a contest or an exhibition of unarmed combat, which an unarmed combatant would be in.
Now, Your Honor, I don't know.
Quite a few words are used throughout these different NAC that implements the NRS.
Do you have my points and authorities in front of you?
I have everything here,
Okay.
yes, I do.
And just for ease and clarity,
I got it.
if you can turn to page 3, Your Honor, which really
Got
has the relevant sections.
Okay.
What they did, Your Honor, just again, so I think
Yeah, I actually have the statute, Mr.
Okay, thank you.
Hold it.
I think the court understands that they actually violated, said that Mr. Silva violated this statute, NAC 467.850. As the court sees, subsection 6 says that you must be a licensee in order, if you find there's a violation of any of these statute or subsections preceding it, including subsection 5, So again, the first level of analysis is, was Mr. Silva licensed? There's no dispute that he was not licensed. Because it's clear and unambiguous on his face, the analysis should stop there. But if the court wanted to go further, because they're kind of playing around with this term, unarmed combatant, if you turn to page 8, Your Honor, also my reply, on my points of authority. If you look down, I cited those statutes that the court probably looked at in the footnote. It says, an unarmed combatant is any person who engages in unarmed combat in a contest or an exhibition. And that's NAC 467.0039 subsection 1. Then you go to the next statute, which defines what's in a contest. All contestants, promoters, managers, seconds, trainers, and ring officials must be licensed by the commission. So there's no independent section which would allow somebody, because what they're saying, even if you didn't have those statutes, which you do, which shows that you must be licensed to be a contestant, again, licensing, what they're asking you to do is to just say that we have jurisdiction over him because he's not licensed and he's an unarmed combatant. Well, if you take the statutory definition, they're even playing fast and loose with the term unarmed combatant because it means somebody who engages in a contest. Obviously, Mr. Silva did not engage in a contest, and following the second section is he wasn't licensed. The statute says you must be licensed before you can compete. Okay, now, so that's 1 and 2, Your Honor, as far as the term unarmed combatant. If you turn to the next page, and this was the mea culpa that I referenced, and by itself is an admission by the Nevada State Athletic Commission. In their findings of fact and conclusions of law, paragraph 35, it says the commission even acknowledged that they only have jurisdiction over licensees of unarmed combatants or unarmed combat. It says specifically the commission is vested with the sole discretion, management, control, and jurisdiction over contests, exhibitions, and licensees of unarmed combat, which includes mixed martial arts. That only makes common sense as well, Your Honor. That's why the legislature did that, because you can't have an agency that can go around sanctioning and disciplining people who are not licensed before them. If they don't like that person or believe that that person is committing drug testing violations, then when they apply for a license, then they would have jurisdiction over him. We'll go get tested and then we'll see how we're going to treat it. But paragraph 35 is dispositive for this petition, where they finding of fact and conclusion of law that they only have jurisdiction over licensees of unarmed combat. And the reason why they acknowledge that, Your Honor, is for the very 2 statutes that we already referenced, which says you need to be licensed. I would also say, Your Honor, I cited to NAC 467.022, and that says before a license to engage in unarmed combat is issued or renewed by the commission. So NAC 467.022. The title of that code is Determination of Ability to Compete in Unarmed Combat. That's exactly what I was just referencing. And again, the very first phrase of that code says, before a license to engage in unarmed combat is issued. So it's not good enough to be an unarmed combatant. The agency needs to license you to engage in unarmed combat pursuant to NAC 467.022. So those, I think those are jurisdictional issues, and the legal issues. I'm not sure if you want to hear from the state in response or if you would like me to go on.
I will do either way, what you're most comfortable. Mr. Eccles, are you more comfortable? Ms. Lumby, I kind of compartmentalize, I do, because there's distinct issues. I don't mind hearing it all at one time, your preference. The court will do either way.
No, I would like to have Mr. Goodman continue and then make my...
That's fine, no problem at all.
Your Honor, is there a possibility we
Oh,
can
yes,
take
Don,
just a
we-
quick break? I'm sorry,
Yes.
because I think we can be out of here in about 30 seconds.
Okay, I apologize. Do you mind,
No,
Mr. Goodman?
can
Can
you
I
guys
just,
mind real quickly? All I gotta do
No,
is...
well, not for Mr. Campbell, Your Honor.
No, I'm just waiting
Mr.
for
Wade.
it.
Mr. Williams.
A
Okay.
648215, because thank you. I tried to get him here earlier. Okay. Well, we had stopped with the jurisdictional argument, correct?
Yes, Your Honor.
So at least we were in a good break. Okay. Then we need to go on, even assuming arguendo that I don't find there's jurisdiction, you still need to address the other issues.
That's right, Your Honor.
Okay.
So, okay. So,
Because I'm breaking it down for me, okay?
so as I said in my reply, the state fails to respond entirely to the third and fourth errors under review. And that's on page 5 of my points and authorities. The third error being that the Nevada State Athletic Commission's desperate or disparate treatment of petitioner by imposing a career-ending sanction for a first offense in 20 years compared to the regularly imposed 9 to 12 month suspensions was clearly erroneous, arbitrary, and capricious. And the fourth error under review is that the Nevada State Athletic Commission arbitrarily fined petitioner based on an imaginary purse amounted to pure speculation, especially given that he had not signed a contract to even compete in a future event.
They went back to say, what did he make in the past?
3 years earlier.
Yes.
Yes.
I'm aware of the fact.
Okay,
And they used that, the transcript explained how they did it.
yes.
Okay?
Or how they attempted to do it, off of Google. But
I
we'll
saw
get
it.
there in a second.
I'm sure I saw Google.
All right, so,
Okay.
so Your Honor, the one-liner that they responded to in their answering brief was just a conclusory remark that, quote, the commission's fine was within the discretion and reasonable. So that was their answering brief to the discussion and analysis of our points and authorities. So they should be, quite frankly, limited to that statement that is just a conclusory response that they believed it was within their discretion and reasonable without providing any
factual
justification.
support? Is that what you're saying?
Yes, Your Honor.
I understood your brief. Okay.
And the answering brief, where Mr. Eccles took short shrift of that by elaborating on it and providing factual analysis. Otherwise, even in spite of at the commission hearing, that Commissioner Lundvall was concerned about an unreasonable penalty that could invite reversal, quote, if it is too far outside the norm of what we have done in the past. And what you hear is what they've done in the past is take a range from an actual purse that person actually earned.
Actually earned.
Yes.
That's not what was like. Okay.
Now, I want the court to understand, and in the record, I took the court minutes, which is part of the record of appeal, at a couple different hearings that Mr. Silva was on the agenda for, and the court could see, without a shadow of a doubt, that people who had violated the drug testing policy, and even people who had multiple violations of the drug testing policy, got anywhere between a 9 to 12 month suspension upwards to a 24-month suspension of somebody who actually was a repeat offender. Here, it is undisputed that you have Mr. Silva, who had a 20-year career, has never had any type of drug testing violation, and then you take this first one where he was, out of competition testing, he wasn't licensed before the commission, he didn't consent to it, and they come in and they try and direct somebody to give a non-consensual chemical test. Mr. Silva did not believe that that was right. He didn't believe that that was permissible. And
I
so,
think he left, didn't he? He
So he
basically
left.
absconded.
yeah, so he left. I mean,
Yeah, I know.
you know, that's as if they came to you and somebody said, you know what, we hear that you're going to be, you know, applying for a license soon to compete in some event, so we want you right now to submit to a blood test. That's a non-consensual test. If you would have said, okay, I'll consent to it, then you have consent. But here you don't have consent, and you don't have somebody who's licensed, so therefore the commission has no jurisdiction to require that person to submit. So they like to say, for sensational purposes, Mr. Silva just kind of fled. Well, you know, they didn't have any right to order or direct him to submit to a drug test. So, of course, we also argued and submitted to the court in NRS 467.158 subsection 3, which is what they cited to, that they are statutorily prohibited from assessing any, quote, penalty against Mr. Silva, as he was not licensed and therefore not considered, quote, a person pursuant to the chapter. And you know that because of the previous statute that we talked about early on, which was NAC 467.922, which says that you can't, the executive director or commissioner can't even bring a complaint against somebody under NRS 467.110 or 467.158 unless that person is licensed pursuant to the chapter. So there is no question, in our opinion, in our view, Your Honor, that they clearly exceeded their licensing statutes, and they retaliated against Mr. Silva by challenging, have the audacity to challenge their jurisdiction to try and discipline somebody who was not licensed before that. And that's the only explanation to support this unprecedented lifetime sanction against Mr. Silva after having stellar and 20-year career over 50 professional fights. So based on that, Your Honor, I'll sit down unless you have any questions.
Thank you again for letting Mr. Williams.
Of course.
I'm so sorry. You know,
And I may, from time to time, ask the court if they would like to see some highlighted documents I brought, which are in the record, or I can just read those, but I want to make it...
You know what, as you go along, if I need it, make it very clear, I'll stop to look, you tell me, because I will be honest, I followed your argument, and you know, there's a lot here. As you know, you have to go from statute to administrative code to statute, I mean...
Exactly,
so,
Your Honor.
believe me, I understand how your argument works, so I do understand you might want to slow down, I get it.
Okay.
I worked hard to try to get it together.
Thank you very much.
And
on that point...
Any help you can give me, I appreciate your side too.
Thank you, Your Honor.
You're welcome.
And on that point about these regulations and these statutes, regulations cannot conflict with the statute. The
No,
legislature...
they are imposed because of what's under the statute.
Exactly, Your Honor.
They can't do anything more, they don't expand anything.
Right. Then the legislature gave the commission jurisdiction, that I'll point out later, Your Honor, but
Okay.
let me just put this in context for the court, if I may. I know the court has reviewed everything,
No,
but
please,
from my perspective, we have an administrative process to deal with these matters. And Mr. Silva was named as a respondent in the complaint. He had counsel. They filed a motion to dismiss. But before they had filed that motion to dismiss, Mr. Silva had already appeared before the commission, and he had said, I'm a contestant. I am a contestant. I ran from this test. I'm paraphrasing. But he did say that he knew that at the time the collector was there to collect his specimens, he knew that he was scheduled to compete at UFC 175, which was scheduled for July 5th, 2014 at Wanderlei Bay Event Center in Las Vegas. In fact, Your Honor, the day before the collector went to collect his specimen, he was up at a press conference with other unarmed combatants on that card that were promoting this event, with the president of UFC, Dana White, there, other unarmed combatants along a huge stage open to all media. They were promoting this event. and he was asked questions in English, he answered questions in English, and this is all part of the complaint, that he understood exactly what was going on when the inspector showed up to collect his specimens, and he made those admissions. And so to further put that in the framework for the court, the commission knew at the time that they heard the hearing on that motion to dismiss that he had already appeared before them. It was part of the record. That he knew that he was being required to submit to a test because he was a contestant scheduled to compete on this card in Las Vegas. And just as I said, Your Honor, May 23rd, he's at a press conference with one of the biggest promoters in the world at one of the biggest hotels in Las Vegas, saying along other unarmed combatants sitting alongside him in front of all the media, I'm on this card, I'm going to compete in Las Vegas, I'm going to beat him up, and so forth and so forth. And the next day we send the collector. And he admits he knows the collector is there because he's on this card. And what does he do? The collector identifies himself. He says, yes, I understand that you're here to collect my specimens. Give me a few minutes. The collector says, okay. He goes and gets his equipment. He comes back to the Wanderlei Silva's gym in Las Vegas, right along the 15 here, and looks around, and Wanderlei's gone. And he talks to someone up at the front. Where did Mr. Silva go? Well, maybe he's taking a shower. I don't know, maybe he had something to do. The collector follows up, as you see in the record, Your Honor. He fled his own gym. He ran out of his own gym because he knew he was going to test dirty, because he was taking a drug that's prohibited at all times.
That was the diuretic.
Yes, Your Honor. And according to the Commission's rules, they have adopted this World Anti-Doping Agency's prohibited list. And it lists specific drugs. And in that list, which is an exhibit to the complaint, you can see that diuretics are prohibited at all times. And in fact, Mr. Silva admitted that he knew he was going to test dirty for it, and that was why he avoided testing. He ran. This was a deliberate, flagrant act. And, Your Honor, I can tell you, I've had nearly 9 years of experience prosecuting cases in front of the Commission. The Commission has never had anyone run on.
I'm going to object, Your Honor. That's outside it's argument. It's outside the record.
Your Honor, the Commission has noticed at the time they do these hearings that they've never had such a similar case.
I'm sorry, was there?
I can't have it. You know my role. I am limited, as you know, because I read the record on appeal.
Thank you, Your Honor.
I have to be limited, as you know. Once again, I even struggled a little bit, and I wondered whether I should use those minute orders that you did, because I was trying to find on the record of appeal where it even talked about what was the regular punishment for this. So, when you look at the record, you all have to agree. It was a tough record. I mean, so I am limited, but I do agree with that. I am limited to the record on appeal.
I take your point, Your Honor. Thank
Yeah,
you.
and I do have to be, and I'm very conscious of that when I do these.
Okay, and so I will.
But
So
I
the
appreciate it if you're
objection
limited. I know.
Thank you, Your Honor.
You're welcome.
And so.
But I did, okay. No,
Your Honor.
I'm fine, I'm following you.
Okay, if I can then focus
Yes.
to that record on appeal.
Yes,
Mr.
thank
Goodman
you.
talked about his motion to dismiss, and so
Right.
in summarizing that point up, again, it is part of the record. Wanderlei Silva had already appeared, he had already admitted these things, and so the Commission knew that at the time. I will also say that if you
Okay,
look
so
at his motion.
prior to when he came, when the motion dismissed was heard, he had already appeared in front of them in another hearing, is what you're
Yes, Your
saying.
Honor.
And I did that, and he appeared. That's where you got the talk, where he made some of the, I don't know what to say, admissions, but you got the information. Okay.
Yes, Your Honor,
Okay.
and I would.
And are you saying to me then, because he appeared prior to that he somehow waived any jurisdictional arguments?
Well, Your Honor, if you'll
You're
allow
getting-
me,
okay,
I'm
I'm
going to
sorry.
get to that, I
I'll slow
think,
down.
and I'll make a quicker path.
No, I just wanted to ask, are we getting there?
Yes.
Okay, all right.
We're getting.
It's okay, I'm following you, I don't mean to jump ahead. Okay, go ahead.
We're going to
Take
focus on
your
the
time.
record then, Your Honor. And so my point being
Okay.
that, yes, he filed a motion to dismiss. In that motion, you can see he didn't even cite the standard for the granting of a motion to dismiss. I put that in my opposition to his motion, and obviously the standard is you have to construe the pleadings in the complaint liberally. You have to draw inferences in my favor as a non-moving party. That it could only be granted if it was beyond a doubt that I could prove any set of facts which would entitle me to relief. And, Your Honor, given the fact that he had appeared there and said that he was a contestant scheduled to compete in Las Vegas again, and those things I've already said, in fact, it was entirely appropriate for them not to grant such a motion.
So, okay.
And so, Your Honor.
So that argument is going to what the commission did as far as a motion to dismiss for lack of jurisdiction.
Yes, Your Honor, and so.
I was trying to go forward, that's fine, okay, I understand that, Mr. Eccles.
And
Thank
so
you.
they did not grant that motion,
Okay.
and then so right after that, Your Honor, it was also noticed that we were set for a hearing on the merits of the case. We were set for the disciplinary hearing. And I don't think this is a situation where you've got, dots all over a map you have to connect here, Your Honor. I think there's a very clear path, and that's what I intend to set forth to the court. So we had this hearing. I would point out, at the hearing, Mr. Goodman was present. Mr. Silva was not. He was asked by the chairman, and this is in the record, page 86, lines 7 through 8. The chairman of the commission, Francisco Aguilar, says, do you wish to file an answer to the complaint? Mr. Goodman says, no, Commissioner. He says, we stand by Mr. Silva's June 17th hearing or testimony before this commission. You'll be standing on his acknowledgement of taking diuretics. Mr. Goodman goes on to say, so we will not be filing an answer, and we concede those factual allegations. Commissioner Lundvall says he's waiving his opportunities and we can go forward. Again, on page 90 of the record, Your Honor, Mr. Goodman says, again, we conceded to those allegations anyway. I go on to say he hasn't filed an answer to the allegations in the complaint. Regulation allows you to accept the allegations as true, and Mr. Silva has essentially admitted those anyway, and that's again on page 90 of the record, Your Honor. And so my point being, he had just had his motion to dismiss denied. The commission says, hey, if you want time to go file an answer, you can have that time to go file an answer. We can come back and deal with this disciplinary hearing. And he says, no, we're admitting things. We don't intend to file an answer. And I'm merely pointing out, and you can track it in the record, that the commission then basically walks him through, and I reference the regulation that says it's NAC 467.924, and if the court will indulge me in just...
Of course. I don't have that one.
Your Honor, I have copies right here if I can approach.
Sure. Thank you.
If I can have a copy, Your
It's
Honor.
NAC 467.924.
Highlighted
Yes.
for you. And Your Honor, he's under an obligation pursuant to these commission's regulations. It says the respondent shall file an answer to the complaint not later than 20 days, etc., subsection 1.
Okay.
And it goes on to follow in subsection 4, if the respondent fails to file an answer to the complaint or to appear personally at the hearing on the merits without having obtained a waiver, such failure shall be deemed to be an admission of all matters and facts contained in the complaint and a waiver of his right to an evidentiary hearing.
Okay.
And so my point is, Your Honor, that obviously the commission gave him multiple opportunities to say if you want to file an answer, etc. And if you haven't, if you choose not to, it's clear you're admitting everything in the complaint. It stands to reason that a person whose motion had just been denied might want to go file an answer, making a record denying things or have a hearing.
And what are you saying he admitted in the complaint?
He admitted everything, Your Honor.
Okay, so are you going the next step? Did he admit jurisdiction?
Yes, he did, Your Honor.
I knew this was coming.
He admitted jurisdiction.
Somehow I suspected this was coming, didn't I? I jumped the gun, but I knew there was something coming.
Your Honor, the administrative hearings have to mean something.
I would not, listen, I am so glad there's administrative hearings. I'm glad my review is limited to what it is. And I'm not, I am a big supporter of administration. So tell me again, so give me your argument, because
Your Honor, given multiple opportunities in the record, I pointed out, he said, no, I'm not going to file an answer. No, my client is not here. He's not going to be here. The commission even went on to ask me, did we give him notice and provide the documents? Did we let him know he could have even appeared by telephone? Yes, he has the number. And Mr. Goodman said, no, we're not filing an answer. He doesn't intend to appear. And therefore, the commission could have accepted all matters and facts in that complaint is true. Now, Your Honor, it gets more interesting because if we look at the record on page 35, this is the second page of my complaint.
hold on, let me find the record. I've got it on the page.
And
What?
Your Honor, if I can approach, I
Okay,
have.
if you have it, that's fine, because I have papers there. I marked everything, okay. You do what you're giving me separate, okay. This is
So, Your Honor,
complaint
this is
against Mr. So I see what it is, okay.
page 35 of the record. I've provided you with pages 35 and 39
Okay.
for brevity here, but you can see on page 35, lines 6 through 8, he admitted this. Silva contracted with UFC to participate in a professional mixed martial arts contest against Chael Sonnen at UFC 175. And again, in the preceding paragraph, it sets forth the date on which that event was supposed to take place in Las Vegas.
Right.
If you look at paragraph number 10, lines 10 and 11, he had appeared on May 23rd at a press conference with other UFC unarmed combatants scheduled to compete at
Okay,
UFC.
so then you're saying that this provides me the facts on the record on appeal. I get it.
Yes, Your Honor. Basically, he admitted everything, and that
Okay,
is,
but
those are the facts.
Okay, all right.
And-
And then
and-
you've
and-
got, go ahead, I see.
And then in paragraph 14, at the time Silva was ordered to provide urine and blood specimens for testing, he knew that he was a contestant at UFC 175. I drafted this complaint very carefully to establish that he was a contestant. He's an unarmed combatant. He's going to compete in Nevada. He's got a contract to fight on a certain date against a certain opponent at a certain event. And they admitted every single one of these things. Okay, Your Honor, that solidifies his status as a contestant. And, Your Honor, if we go to the next page that I provided, which is,
So the admissions on of complaint, he knew that he was a contestant, so that gets you to contestant, okay?
yes, Your Honor.
Okay.
Right, and Your Honor, I was pointing out his contestant status, and if Your Honor has page 34 of the record, you can see, obviously, that's the first page of the complaint that sets forth the jurisdiction, alleging that he is an unarmed combatant and contestant in professional mixed martial arts contests.
Okay, so you're hooking up an armed combatant with contestant.
Yes, Your Honor. And that's exactly what's alleged in the jurisdiction, and again, by not filing an answer, and by, he specifically waived his right to an evidentiary hearing. He admitted all of these things. Any and all matters contained in the complaint have been admitted to. That's what the regulation says. And so he admitted everything.
So, I just want to make sure I follow your argument, because if it was in your brief, I really didn't follow it quite, that you were saying it this way.
Okay.
So I want to make sure. So what you're saying, because he failed to file an answer to the complaint, then everything within that is deemed admitted. I understand factual. And are you saying then also a jurisdiction, he is then, it can't be but a waiver that the commission did not have jurisdiction?
Yes, Your Honor.
I just want to really make sure, okay.
Yes, Your Honor. He admitted to everything.
So by his admission, you're saying then that's a waiver of the jurisdiction?
Yes, Your Honor.
Okay.
He didn't just, waive that by not filing an answer. He appeared there and said, we concede those allegations. And I'm just pointing
Your
out.
second point is, and by making an appearance at the disciplinary hearing, he also waived, even though he filed a motion to dismiss for lack of jurisdiction at that same hearing, you still say that's a waiver. All I'm doing is trying to follow. I'm not trying to be the devil's advocate. I just want to make sure I follow.
Yes, Your Honor,
Okay.
I am.
Okay.
If the motion
No.
was denied, I pointed out they had a
No.
basis to do that because he had already,
Okay.
in my view, admitted at a prior hearing that he was a contestant. Then he should have filed an answer if he intended to contest any of the allegations. He could have just made an argument at the hearing, but again, he said, I'm standing by his testimony that he was taking this prohibited drug. And I
Okay.
admit everything. So that's the record that Your Honor has to deal with here.
No, I'm getting the record. Okay.
And so I would just also point out, Your Honor, given his status as a professional mixed martial artist, I've alleged that in numerous paragraphs, but particularly those that are at the beginning of the complaint. He had competed in numerous contests in Nevada, and the commission obviously knew that, and by his own admission, that he was scheduled to compete here again. And now,
Okay.
so Your Honor, can make, let me see, I do have another, I think it's a pretty good point for the court. I have another document, and it is just the findings of fact, conclusions, and order. And if I could approach from it.
Yes. Absolutely.
And that's obviously,
It's part of the record.
yes, Your
Can
Honor.
I have a copy, counsel?
Yes, sir.
Thank you.
And so, Your Honor,
Part of the record. Okay, yes.
having admitted all of those allegations, which they're bound to, now that they have admitted them, they're bound to those admissions to this court, the commission, then produced an order based upon those allegations. And that's what I mean about, you don't have to go and connect dots all over a map here to get to where I'm taking the court. This is pretty clear because we have a case where the respondent came in and said, yes, I admit I was a contestant on this card. I was taking this drugs. I was at this press conference the day before. And then you have a hearing where counsel says, yes, we waive everything. And so that's the record, Your Honor. And then
once
you have
again,
an order.
so I understand your argument is that he waived any jurisdiction issues.
Yes, Your Honor.
Okay.
And then we have
Okay.
an order based upon that hearing, which is basically mirrors the allegations of the complaint. And that's exactly what the commission is supposed to do. They're supposed to look at any admissions or any evidence, and here, which is all admissions. And they're supposed to make findings based upon that evidence, substantial evidence in the record. They admitted everything again, so that's what the order is based upon. And you can see in the order, and I'm referring to the record on page 114.
I see it.
Paragraphs 24 through 27 say, Silva did not request, nor was he granted a waiver, and I refer to that regulation, which they walked him through that at the hearing. He failed to file an answer. He failed to appear at the hearing. Pursuant to that regulation, NAC 467.924, his failure to file an answer, failure to personally appear, constitute a waiver of an evidentiary hearing and an admission of all facts alleged in the complaint.
So is jurisdiction a fact? When you say,
Well,
I see.
he admitted
I
to
know
all
I'm
facts in the
nitpicky, but
complaint.
is jurisdiction a factual allegation that he could admit to?
Well, I would say, Your Honor, that's the record you're dealing with, and,
No, I'm-
you're,
But I need to go that next step in my mind.
to the law.
Yeah,
Yes, Your Honor, I'm aware of that, and
I
I
know
would,
that law gets in the way, doesn't it, Mr. Evans?
well, I think I've got great facts, and I
You
think
do,
I've
but
got some
I
pretty
see
good
where,
law.
and I see where you got the factual things. I'll be honest, I read your, a piece,
Okay, and so I'll get to the law then, Your Honor.
okay,
The regulations cannot contradict, again, the statutes.
right? Okay.
Mr. Goodman keeps referring to these regulations, but the legislature gave them their jurisdiction in the statutes. And if we look at multiple statutes, we can see not only that the commission has this jurisdiction, but they even have certain duties to do testing that is in
Okay.
training, Your Honor. And so the first one is
What's the first statute?
NRS 467.110, which provides that the commission can discipline any contestant.
NRS 467, I have here 110.
Yes, Your Honor, they can discipline any contestant is the word that's used. And again, the record, to match the law with the facts here, the record establishes he's admitted he's a contestant. Okay? So then we have NRS 467.158, where the word used there is they can discipline any person regarding his preparation for a contest up to $250,000 or 100% of the purse, but it's an or. So
They can discipline any
person
for preparation of a contest.
Yes, Your Honor, and that's NRS 467.158.
So how far out does that go?
Well, Your Honor, if the person has been at a press conference the day before saying, I'm going to compete on this card in Las Vegas, and we know that they have a contract with this promoter, and they've admitted they're a contestant.
So that's far enough for you, for
I
our
think
purposes.
we've gone,
I'm just
yes.
thinking
I
as a
don't
lawyer,
know where that
how far
line is.
out could that statute apply? I'm looking, you know, it's a little vague to, because I should try, you know, how far out could that go? Could that be somebody who hasn't signed a contract yet, but is talking to Mandalay Bay or Dana White and saying, you know, I really want to compete, you know, and I'm working out, and you know, what, I don't know, whatever they do. I'm not a fighter person, but that's okay. I know kind of, you know, what they do. Would that be in preparation? I'm just trying to think.
I don't think we,
You don't need to get there.
we
I
don't
get it.
have to
Well,
get
I
there,
have to
Your
decide
Honor.
if it's fair. Okay.
But I do think that matching the facts with the law, he's admitted he's a contestant, and the law says we can discipline
Okay.
contestants.
Okay. Let's just go that route.
And
We're back to the admission. Okay.
And so, again, NRS 467.070, the commission has this sole
NRS 467 point, I have them all here.
070.
Got that. Okay.
The commission, again, they have sole jurisdiction over all contests to be held. So it's, you know,
Sole
it
direction,
anticipates
management,
something.
Control and jurisdiction over all contests or exhibitions of unarmed combat to be conducted, held or given within, and no contest or. And see, it's okay.
And so the language of that statute obviously contemplates that they have some jurisdiction over things to be held in the future, things that are going to happen. They have that jurisdiction. And then,
Okay, let me
Your
just
Honor.
make sure I'm right. Things to
Okay.
be held in the future. Okay. Use under this statute.
And
And I
Your
have your
Honor.
NRS 467.070. Okay.
I have another great statute.
Okay.
And I would like to give it to the court.
That's fine.
Okay, thank you, Your
You
Honor.
have every right to give anything to us. Okay.
Okay.
NRS.
This is a great statute for my argument, I think, Your Honor. NRS 467.108. What's great about this, Your Honor, this is new language that I'm going to refer to that was passed by the legislature in 2011. So this is pretty recent language. And if you look at sub 3 here, you can see that money is collected from ticket sales, and this is the legislature. It says these funds must be used. It's a directive. They have to use funds to 3B, to perform random drug testing of amateur and professional unarmed combatants at any time, including without limitation, during any period of training. And Your Honor, I would submit to you, it just, you know, it probably goes without saying, but any person that's preparing for a contest, that the preparation for that is obviously in the weeks and months before that, and they are mandated to use certain funds to go test these people for prohibited drugs, including during any period of training, which obviously occurs before the contest itself, Your Honor, in the weeks and months prior to. And that's exactly what they did here. They were testing someone during training of the preparation for a contest. Your Honor, now I think it's a good time to add something in here about the whole purpose. Obviously, I just need to get it in the record, I think. The commission takes very seriously these sports, the regulation of the unarmed combat sports, which again, I don't know if Your Honor is familiar with. These are just boxing, kickboxing, or mixed martial arts, different forms. And obviously, these are people that they're throwing strikes intended to inflict injury upon an opponent. You need the elbow strikes. You can get hit with an elbow in the head, Your Honor. This commission takes the health and safety very seriously because these sports are inherently about throwing strikes that are intended to inflict injury. Obviously, how you win these things. They don't want anybody going into the cage or the ring that has been doping, and they carry that advantage with them into the ring or the cage. And so obviously, they've just been mandated in 2011. They have to go test these guys during any period of training, which occurs obviously before the contest itself. And so again, I think that gives the commission jurisdiction here, along with all the other statutes. And again, those are all statutes, not regulations. And if there is a regulation that seems to contradict, the statute controls. And it's basic, tenet of statutory construction, obviously.
Right, obviously.
So-
I know NRS. Okay.
So, Your Honor, they have direct statutory authority to not only test and discipline, they even have a duty And that's new language. I attached the second page of that. You can see, I attached the Senate Bill 498 showing on the second page here that matter, that 3B saying that they must perform random drug testing to include testing without limitation during any period of training. That was new language added in 2011.
See.
So this, this is a structure that is in place. They have authority to do this. And I think that basically summarizes my argument on the jurisdiction, Your Honor.
Let me ask this, how does it interplay with the argument that he wasn't licensed? Because that's really the crux of the whole thing. Mr. Eccles, if I boil it down to how does that, and I'm not familiar with this, how does that interplay with when they are licensed? Are they and you tell me, it wasn't clear in the brief.
No.
Let's say was he licensed at this time? We knew he was, you gave me the dates. He was at Mandalay Bay and he was promoting with Dana White. I mean, that's the big leagues, I get it. Okay, when would was he ever licensed before the event? Do they get a license, or how does, just tell me how that occurs, because honestly, it wasn't addressed in the brief, and that was one of my issues.
So the rule is that a person must be licensed before they actually compete in one of these contests.
Okay, before they actually get into the ring or whatever, the cage or whatever.
Right.
Okay.
So in other words,
sense.
that makes sense too, because then if someone does, and we've had people do this, people come to Vegas and say, they start advertising, I'm going to put a boxing show on, or I'm going to, do an MMA show, and we obviously send them letters and say, you're subject to this jurisdiction, you can't do that, you must be licensed if you're going to do this.
Okay.
That gives them authority, to do that, but the truth is, and you can see it in the statutes, they refer to unarmed combatants. Again, if the legislature wanted to say only licensees in all these statutes, that was an easy word for them to put in, but they say unarmed combatants.
I understand they use unarmed.
Okay,
so my question is, he wasn't licensed yet for this event because the time hadn't come. Is that what you're saying? It wasn't at the stage where you would have given him the license. He was going to have to be licensed before he entered the ring at Mandalay Bay.
Yes,
Your
Honor.
That was my question. So can you just tell me, when does the commission usually do this? I don't know your procedures.
That is kind of a long answer, Your Honor. But let me do my best. I'll do my best.
I'm just wondering what the normal customary procedure is when they do license, since the argument of Mr. Goodman bases on licensing. Yes.
I mean, I would be remiss, Your Honor, saying that and this is pure argument.
Let me ask you this then. But my question is there a statute or something that I can refer to that tells me when they are licensed? I can certainly look at that, because that is the law, because the record on appeal is limited to the facts and circumstances. So is there any such thing? Because I actually tried to find something, and because the licensing is a big issue here, and it really wasn't. Is there such a thing, or?
Yes, I think so, Your Honor.
Okay.
If I can.
If you can give me
I think that the jurisdiction of the commission, and my argument is basically
yeah,
that
I have that argument.
that was defined by the legislature as if they're an unarmed combatant. That's their jurisdiction. It's not necessarily required that they be licensed in order for them to have control. And again,
for them to have jurisdiction. I understand your argument.
Yes, Your Honor.
Okay.
And in fact, it's called licensing and control of contests. That is one of the major titles of the statutes here. So
licensing, okay.
And control. And again, the commission has control over contests to be held, etc. But if you're looking for something, and you try to answer your question, NEC 467.
Do it again, I'm sorry.
NEC.
Oh, it's a regular.
It is a reg.
Okay.
467.012. And if you go down, licenses, if you go down to the arrow, Your Honor, it's past M. I can bring it up to you if you want, Your Honor, but it basically says the...
Is it something you handed me?
No, Your Honor.
Okay,
it's
I don't
just
have an
part of the
arrow
regs.
to go down to.
It just says an application for a license must be made on a form
Okay.
supplied by
So
the
there's a
commission.
procedure.
The commission may act on an applicant's request for a license before the form is submitted, but a license must not be issued to the applicant until the applicant complies with these sections regarding licensure.
I
It's kind of a general section.
I think I have it together now.
It sort of basically says, before you actually get in there and do this, you need to have filled out our form.
Right, and I understand your argument. It's not, your jurisdiction at the commission is not just licensing, but also control of people who are not yet licensed. Okay.
Right, Your Honor.
I got it.
And for example, I say it was a
And
complicated
hence
answer.
why I went through all these statutes. Okay.
As Your Honor knows, I'm sure people come from all over the world to fight here.
Oh,
And so there are many issues with getting documents from them, such as medicals, which are required, and as well as other forms, MRI brain scans, getting those documents to the commission. So the commission asked them to provide those documents because of their status as an unarmed combatant.
Before they'll even license them.
Yes, Your
That
Honor.
would make sense.
Yes, Your Honor. So all those medicals, negative STD results, HIV results.
No, I understand your argument.
Okay.
You're saying to me, based on, we feel we have jurisdiction of not just license, because that's a very, I understand, limited, and that may be done just a little bit before, by the time we get medical records, by the time we, whatever we do, but we feel we have to do also control, because they may be, and out there taking diuretics, already whatever all those things are, that would actually enhance or in some way control their body when they're doing this event.
Exactly.
I follow.
And
I follow. So I follow the distinction. I'm just trying to legal-wise pull it together.
Right,
Is what
and
I'm
so,
doing.
yeah,
So,
you summarized it, I think, very well.
Okay, all right.
Shall I move on?
Try. Yes, you shall.
Okay.
By God, the judge gets it, I think. I'm trying very, okay, no
So-
problem. And I get your admission argument on the jurisdiction. I see where you're going there, okay. So are we finished with jurisdiction?
I think so,
Okay,
Your Honor, and I would move.
I
to
have
the-
a bit, I'm solidified more in what your side was. I will be honest that very few cases, sometimes I feel like I need oral argument, but because of this record, this is very helpful. Okay?
Okay.
Okay, so now we're going
Move on to
to
the commission discipline?
Yes,
Okay.
the sanctions. I'm ready, Mr. Eccles, which is important too.
Your Honor, I think that I had referred to Mr. Silva, the complainant, as a veteran unarmed combatant. I obviously listed events that he had competed in Nevada. This is a guy that had competed here multiple times. He knew the rules. He was charged with knowing the rules because of his status as an unarmed combatant and having competed multiple times in Nevada. So this guy had a lot of knowledge about how these things are conducted in Nevada. Okay? And when he's at a press conference on May 23rd saying, yeah, I'm going to fight this guy, Son, and I'm going to beat him up, I'm here promoting it, the world's biggest MMA promoter, and then we send a collector out, and given his knowledge and experience, he runs out of his own gym. That's one of the most, it's the most flagrant violation that you can do. What else can you do? You can submit urine showing that you use steroids, but that's not, what happened here. Instead, he ran. The collector identified himself, and he took off.
So that fact, so let me ask, so that fact because he avoided, I said absconder, but I'm doing too much criminal
Yes, given
law.
his knowledge.
Okay, to giving his knowledge, that, which is kind of what I mentioned a little bit with Mr. Goodman, I could read between the lines, that seemed to be a fact that the commission, when you read it, took into account as one of the basis for the sanction, and that's what you're just arguing to me, right?
Yes, Your Honor.
Okay,
And,
all right. Because he ran.
I don't want to get outside the record, but obviously when the commission hears these things, they know their history. They're charged with knowing their history and how to, have reasonable sanctions against these guys. Your Honor, I don't know that it's outside the record because they are charged with having that knowledge, and they knew that no one had ever run from a test before. They knew that at the time they did their order.
I don't know about that, because that's a factual, but they didn't put that as one of their bases for reasonable, because I looked, I saw Miss Linville worked on the reason. Okay,
It was the most flagrant violation we have ever seen.
Well, Your Honor, I'm going to move to strike that.
I will
And
say
if I
I'm
have
not
a
gonna
ruling,
listen to
thank you.
that. I'm
Thank
not
you.
gonna listen.
That's outside the
Because
record.
it certainly was not in the record. 'Cause I
Right.
didn't
Your Honor,
look-
I can tell you what is in the record.
Yeah, okay, because I looked at the record very carefully. Okay,
What you see in this record, and I moved for the
Let's go through,
written,
because the record is what I'm limited to.
I moved for the written admission of Jim Guernsey's comments that he had prepared while he was trying to collect specimens from Mr. Silva. And counsel agreed that those could be admitted into evidence, and it is.
Okay, tell me what that is.
Okay, so Mr. Guernsey is the commission's expert for collecting specimens.
Okay.
It's in the record, he's got 34 years of experience. His job is to go to locations around the world for various agencies, pro basketball, et cetera, and find these athletes. And, Your Honor, he's got a procedure for this stuff. Pull your pants down, put your arms at your side, and I watch you pee into a cup. And he's a license to take blood as well as a phlebotomist. So, and he detailed everything that he did here to collect Mr. Silva's specimens. And it's clear in the record, the only reason that the executive director, Bob Bennett, knew the location of Mr. Silva and his schedule is because the promoter is obviously working with us. They say, oh, okay, you want to test this guy? Well, here's his schedule. And then so we provide that schedule to Mr. Guernsey, and it's in the record. And so Mr. Guernsey first goes to Wanderlei's house. He's supposed to be at his house at that time. No answer. You can see he calls his cell phone. It doesn't work. And it turns out later in his testimony, and I'll get to it, he's off by 1 digit. Go figure, he's off by 1 digit on Mr. Silva's cell phone number. But he then goes to the gym. Bob Bennett is directing him, okay, go to his gym then, he's supposed to be there if he's not at his house. So, all these efforts, Your Honor, he goes to his...
This wasn't in the record. Statement not being made.
Your Honor, I'm going to
I
really
couldn't hear what
object
she
to...
said, I'll be
Okay,
honest. 'Cause
thank you.
But
I mean, if the judge can, the court can admonish other parties not to make statements during argument, it's completely improper.
Right. I do not mind you giving him notes on the record, and I appreciate this isn't in the record, because as you know, I have got, that is my directive. As much as it's tough to do this, but I do appreciate that. And Ms. Linville knows, I understand,
But as an officer of the court, I cannot sit here and allow Mr. Goodman to suggest that the statement that I made is not in the record. In fact, it is in the record.
Okay.
It is
but you're here as a client. I know it's tough. I know an attorney-client is probably the worst thing. It is a horror story for every attorney. So, Mr. Eccles, but I do. If you want to pass him notes, yeah, I have no problem with that. I allow people to do that at trial, but I cannot have verbal because it is distracting. Okay, and whatever you want to correct for me on that, however you want to say it, I'm perfectly willing to listen to that because the record is important for all of us. I understand it completely. So
I'm sticking to the record, Your Honor.
okay, thank you.
So, just to further discuss, there were extensive efforts, Your Honor, and I'll try.
No, I'm not asking you to agree.
There are extensive efforts in coordination between the promoter, between the executive director, and between the collector and the athlete here to get these things done.
And you pointed to me, that's what Mr. Guernsey, and it has an Exhibit A here, and
Yes, Your Honor.
I actually looked. Okay.
And you can see the commission knew all this, that as soon as Silva fled from his own gym, Mr. Guernsey's asking the staff, hey, what's going on? Where did he go? And they give him some story of, oh, maybe he had to take a shower or something like that. Well, then, guess who calls the front desk at his gym? Mr. Silva's wife calls and says, hey, what's going on? Yeah, we didn't expect this test. Can we do it next week? Can we do it later? And Mr. Guernsey goes on to explain that's not the way this
random
works.
testing.
That's not the way this works. You need to tell your husband to get back here. And if you have a problem with it, call Bob Bennett. Okay? And I won't belabor it, but it goes on to detail there were extensive efforts throughout that day to give Mr. Silva a further opportunity to come back and submit to testing. Instead, Your Honor, and this is in the record too, he, a few days later, apparently showing up in Brazil, and he did a YouTube video, and he put on this YouTube video. It's part of
Well, Your Honor, I'm
it is part of the record.
But we're in the record, because if it's in the
I'll
record,
give it to you if you...
if you give me the site, because I am very conscious of what's in the record. I didn't pull Exhibit A, it's down here. I have notes on it, because I did read Mr. Guernsey, gosh,
What did you say, exhibit A or H?
A is an apple. It's part of, it's Exhibit A to the findings of fact, conclusions of law and order by the Nevada Athletic Commission, State of Nevada.
Right, and
It
it's
is in the
page
record.
39 of the record, Your Honor.
Okay.
He shows up, he does this YouTube video, he
Okay.
says, and I'm referring to paragraphs 52 and 53
52, 53.
and 56 on the record 39.
On page 39 of the
Yes.
record on appeal, that's fine,
He
okay.
does this video that is available for everybody, and he says, it's all a big confusion. He says, my fight will be in Las Vegas on July 5th. So we were more than 1 month from the fight. This is the fight I want the most in my entire life, and I will do everything I can to make this fight happen. All of this will get resolved, and I will be there on July 5th to put on a great show for all of you, my friends. And then again in paragraph 56, during the Commission's public meeting on June 17th of 2014, Silva appeared and admitted that he fled from the Commission's random drug testing because he was using a prohibited drug. And again, that's in the complaint, but those were all admitted. That was all.
Mr. Goodman doesn't even, that is not in dispute.
Okay.
What his admitted, I mean, I understand.
And so, Your Honor, if I could bring it back to the
So that's
framework of
yeah.
why this
You
is a
did the
harsh
sanction,
penalty.
you did, that's where, that's, yeah,
Why this is a harsh penalty. The Commission goes through great efforts
okay.
to test these guys. We gave them multiple opportunities, even after he had fled on that day, as you can see from the record. We worked with UFC staff to find him. We're having communications with his wife. We're calling his cell phone. The cell phone is off by one number, as we found out. And in the record, Your Honor, on page 93, you can see, and I can bring it to the court. Your Honor,
You got a copy?
no, I've got one. I'm sorry, it's 93. Do you have your record?
Of what the?
Who is the unidentified male speaker?
Well, Your Honor, that would be a commissioner.
Oh, because he says, and Mr., okay.
Because, and you can tell it is because he refers to another commissioner by his first name, Bill. But the point is, he says this is abhorrent behavior and dodging the test, Your Honor. So there is something in the record. This was the most abhorrent behavior they had seen. That's the reason for the penalty. And Your Honor, again, about the fine, that NRS 467.110, they can fine any person if it relates to the preparation for a contest up to $250,000.
Under, give me again, what can, even if, oh,
That
I
is-
understand that, but the basis for the fine, where's the basis to go back to? I mean, I understand a violation, if someone made money, if they got a purse off a fight and they were found in violation, it makes complete logical conclusion that they should not keep the proceeds from something that they did in violation of the commission.
Yes.
I read it that way. I guess what I was looking for is what in the record you have to say, okay, since he obviously hasn't participated yet, hasn't made any money off this, we're doing this so he cannot compete, or we're looking at him now and deciding whether he will or will not compete in July. And then they went back to, I think it was Ms. Linville, went back to what did he make in the past, sort of thing. And I was trying,
Yes, Your Honor.
the basis for
And they were
that.
trying to find a reasonable fine for him, and they have the authority to do so under NRS 467.158, which
Okay,
says that the commission can discipline any person regarding his preparation for a contest up to $250,000 or 100% of the purse.
okay.
So obviously the commission saw, hey, if you're saying there wasn't a purse here yet, that's an or. We could have fined you up to 100% of the purse, but we can also fine you up to $250,000.
I mean, do you mind if I just look at it real quick? I have it
Oh,
right in
sure.
front of me. Because I marked it, see. And tell me again how your argument on that, they can fine up to, even if they haven't participated,
Yes, Your Honor. And that's
does not
the reason-
relate to a contest or exhibition. I see what you're saying.
Right, so there's two
I see.
subsections there. One is if it does relate to a contest or exhibition, the other is if it doesn't. And but the penalty is basically the same. It can be $250,000 or 100%.
Not to exceed 250,000.
Yes, not to exceed. So they knew they were capped, Your Honor. And they went well below the $250,000 they could have fined him. And they made an attempt to make it reasonable by looking at a person in the past. They said, well, we can fine him up to $250,000, but instead of just fining him, saying, hey, you're fined $250,000, let's go in the past, yes, let's look at what he's made in the past to see what his purses were. And they found that, you know, they decided rather than fining him
Was that the
max.
legal part?
No, Your Honor, I think we
Where was the
actually
part?
had someone.
Okay,
I'll-
I'll find it, because
okay.
maybe Mr. Goodman, I know I put that down as an issue when I went back.
I believe Executive Director Bennett had
Did?
his staff, someone went and looked it up, and they also provided that to him at the hearing.
Okay,
But in any case, they decided that it was reasonable
okay,
to fine him less than the full amount that they could have fined him anyway.
okay.
So,
So part of your argument is it's reasonable because they could have gone up to $250,000. If they were here with a $275,000 fine, I
I couldn't defend it, Your Honor, if it was
Yeah.
$275,000.
Okay,
In closing,
not
Your
to
Honor?
exceed, I get it. I'm sorry, yes.
Just in closing, so I know the court's aware, but yes, we're subject to the restrictions in 233B. We're subject to the record that has been made in which they've admitted everything. And the court knows my argument.
No, thank you, I understand it completely.
And just given, you know, the case law is about the court cannot substitute its judgment regarding these
Correct.
factual matters when they've already admitted them.
I can only decide if it's clearly erroneous as
And
a
also-
matter of law and not an arbitrary and capricious. I know my standard of review.
Thank you, Your Honor. And you know, with
I'm
regard
within
to
that.
with regard to an agency's interpretation of its statutes, they're also bound to some, that they have some deference in that this whole legislature gave them these rules. They are they have, again, the sole discretion, the sole control
And
over
you're-
these events.
And tell me if my understanding of your argument too is, if I ruled that they had to be licensed, that would take away a big part of what you feel, what your agency has been doing in the past. I get it.
Yes, Your Honor.
Okay,
They rely on being able to do this in order to get all sorts of brain scans, drug tests. Women that compete now, we get pregnancy tests showing that they're negative for being pregnant before they even get their license. That's all unarmed combatants requirements to provide these things so that they can make sure that, you know, the health and safety of the contestants. So that would be that is a very large part of their practice. They rely on the statute in order to fulfill their statutory duty to protect the health and safety, and I believe, do some deference in interpreting their own statutes under various case law. And I can cite it if you want, Your Honor, but I know the court's aware of it.
I am aware of that case law.
And so that
Hence
concludes my
probably
argument.
why I have the standards I have for review.
That concludes my argument. If you
Okay,
have questions,
thank-
Your Honor?
I hope I didn't interrupt, but I ask them as I go along because it's easier for me to follow than waiting. So I hope I didn't interrupt you too much, but no, you answered what I needed and I appreciate it.
Okay, thank you, Your Honor.
I do it that way. Okay.
At the very beginning, I think the court nailed the issue, which is, we're here under 233B. Did the commission exceed their statutory jurisdiction? 90% of what you heard is all the factual issues, the factual record. The court was correct in questioning Mr. Eccles that the court or the petitioner does not waive jurisdictional issues. That's black letter law. We filed a motion to dismiss. We preserved that jurisdictional issue. And the standard is not that the court does not substitute their judgment on any subject matter jurisdiction. It's de novo, and the court understands that. And so when the court's looking at this, at whether or not the commission exceeded their statutory jurisdiction, the court has to evaluate that de novo. Whether you don't waive subject matter jurisdiction. So in the way to determine whether or not, in this case, the court exceeded its statutory, the commission exceeded its statutory jurisdiction, is to look under the statute that they disciplined Mr. Silva under. NAC 467.850. That's the
Your Honor,
statute.
that's not a statute.
And I know what NAC
It's a
is.
regulation.
It's an administrative regulation.
but that's the code that the commission violated, deemed.
I know the difference between NAC and NRS, so even if someone mistakes, I do, I will tell you I do. I knew what you meant, I wrote it down as NAC.
Deemed to be a violation.
Right.
Did you hear anything? That's what they violated and disciplined Mr. Silva under. And they still refuse to talk about the jurisdictional requirement under NAC 467-850, which is subsection 6, which says a licensee, that's the operative word, Your Honor, a licensee who violates any provision of this section is subject to disciplinary action by the commission. So then the court needs to ask herself, is that clear and unambiguous, or is there some ambiguity in what licensee means? And we submit to the court that there is no ambiguity. There's clear and unambiguous language that in order for the commission to have statutory jurisdiction to discipline Mr. Silva or anybody, as it says in that code, that to violate them for a drug testing violation, you have to be a licensee. You heard nothing from a legal perspective that rebutted that. Now, then we drop down, Your Honor. Like I said, they didn't even allege this in this complaint, but later on, and they put it in the order, they put NRS 467.110, which the court just looked at, and NRS 467.158. If you look, those are licensing statutes. The heading is licensing. Now, you just have to look at the code. You don't throw away the code. The code's there for a reason. And again, on page 2 of my reply, I cited, the executive director or commissioner may institute disciplinary proceedings described in NRS 467.110 or 467.158 against a person who is licensed pursuant to this chapter. Not any person pursuant to the chapter. That person must be licensed. So when Mr. Eccles just stood up here going back to whether or not the sanction was reasonable, what did he tell you? He went to 467.158 regarding what the penalty is, up to $250,000. 467.158. That's what he just told you was a statutory basis. But now the court knows in NAC 467.922, the commission cannot even bring a complaint against Mr. Silva or anybody unless that person is licensed pursuant to the chapter. So those are licensing requirements that the legislature conferred upon the commission in order to act. And again, as I said in my opening, if they don't like that because it doesn't allow them to throw out a bigger net to get more people because of timing issues, then they need to go back to the legislature and get those statutes amended so they can act accordance with the statutory jurisdiction. But that's it, Your Honor. Those are the two statutes that they violated Mr. Silva under.
Mr.
Okay.
I follow. You may not think I'm connecting the dots. Linda will probably laughing at that because she taught me to use that.
Actually, we did.
But you do have to. You know, I do understand how it's.
I know you do.
That's why I'm making sure I understand everybody's argument because the court will tell you this is not simple. If it was simple, I wouldn't be here connecting the dots. But I do understand, and I understand the ramifications. I certainly understand that too, for both sides.
So the question is, from a legal standpoint,
Right.
Your Honor, did the commission exceed their statutory jurisdiction by those two statutes? And the only answer that anybody can come to looking at those two statutes is, of course he did. Mr. Silva was not licensed. Now, the court has to take into consideration that the commission acknowledged in their findings of fact and conclusions of law that they only have jurisdiction over, quote, licensees of unarmed combat. And that again is paragraph 35 of the findings of fact. And the reason they put that in there, Your Honor, is not by accident. It's because of what we just went through on NAC 467-850, that the person must be licensed. Now, Mr. Eccles was trying to, I'm not going to say confuse the court, because I know the court understands all the issues, but saying that we filed a motion to dismiss, the law is clear that you never waive subject matter jurisdiction. But he...
Mr. Goodman, I'm aware of that.
I know.
It's
I would
more
be-
that, I'm aware of that one.
I would be remiss, though, Your
No,
Honor,
that's
just
fine.
to say that he gave you the code 467.924,
Yes.
subsection 4, subsection A, as the court already pointed out in questioning Mr. Eccles. Those are admissions of matters and facts. At that point, when the commission did not even give me the time of day and did not even respond to any of these legal arguments regarding no jurisdiction, we knew that it was a lost cause. Mr. Silva did acknowledge that he used diuretics to try and reduce his inflammation so that he could go fight. That is a prohibited substance. So there was no reason for me to file an answer since he already went to a hearing and acknowledged all that. But he obviously preserved his subject matter jurisdiction, and just the black letter law that we cite in the reply says that you don't waive subject matter jurisdiction, which is why the standard is de novo review. So again, when he cites to 467.158 subsection 3 to tell you that, hey, the commission was reasonable in assessing the penalty because they had the ability to fine up to $250,000, that, as the court knows, the commission is not even allowed to file a complaint, much less penalize somebody unless the person is, quote, licensed pursuant to this chapter. And that is clear and unambiguous language in NAC 467.922 subsection 1. Now, it seems like the court, the state, that Mr. Eccles is basically saying, hey, but you know what, forget about our statutory jurisdiction over only licensed people. That doesn't really accomplish what we need. We should be able to go to anybody. Because in this case, Mr. Silva went to a press conference and he said, hey, I want to fight and all that kind of stuff. Well, that's not what their jurisdiction is limited to people who are licensed, not people who are giving press conferences. And I would submit to this court that if they want to expand their jurisdiction, then they go to the legislature and argue basically what they just argued here. But none of that does away with their licensing requirements, which are clear and unambiguous. The fact that somebody does a press conference to say that they are going to fight in a future event, so what? You know, maybe if they don't go to the legislature, they can have a talk with their other licensee, the big promoter that they've been referencing, the UFC, and say, you know what, since we have jurisdiction over you, UFC, you're not going to allow somebody to go to a press conference unless they first apply to our commission for a license. There are other ways to do it, but just to say to this court, hey, that doesn't really serve our purpose, and we want to expand our jurisdiction, that doesn't give them statutory duty to do so. Now, we don't have any control over how Mr. Eccles drafts his findings of fact and conclusions of law. I've acknowledged throughout this whole proceeding, even at the commission level, that Mr. Silva acknowledged that he used diuretics. He was not waiving jurisdiction because that's the whole purpose of 233B, which is that they act in excess of their statutory jurisdiction. And not only, and by the way, Your Honor, there's two subparagraphs of that, whether or not they acted in excess of their statutory jurisdiction, and then whether or not they violated their statutory jurisdiction. When we said in our reply that they met both of those statutes.
I understood the distinction.
I just set it aside. But to sit up here and to say that Mr. Silva had a contract to fight in a future event is disingenuous because, as the court can see in the record, trying to find out about what the fine should be. There was no contract to fight. And that was said throughout our pleadings, that not only was he not licensed, but he didn't have a contract to fight in a future event, which is why they couldn't find, what the amount was. As you can see in the record, the commission was asking representatives from the UFC in the audience, and they said, we have no contract. So to say, just because I didn't answer because we didn't see a need to at that point because we admitted to diuretics. Now they want to take advantage of that fact and say, when they know full well, based on the record, that he had no contract just because he puts it in the findings of fact and conclusions of law. That is disingenuous, to say the least.
Well, this is their findings, based on the
Yes,
record.
Your Honor.
I understand that.
Now, even though we went over this up on my first time around, they want to keep on saying that Mr. Silva acknowledged that he was a contestant, and so that's good enough. And again, that's not good enough, Your Honor, and just to point out again, the statute says all contestants must be licensed by the commission, 467.1001, subsection 1. Now, so just because he acknowledges that he's a contestant doesn't make him legally a contestant. He was not licensed.
It's the statutory interpretation of
Can I get to
the...
this? If you just want to turn a page, okay.
I have it.
So, as the court can see, there's nothing in here about licensees or about people. This is just talking, yeah, they have jurisdiction over all contests or exhibitions of unarmed combat. There's nothing in there talking about their jurisdiction over people. And those statutes are the ones that we already talked about, requiring all contestants and unarmed combatants to be licensed.
Okay, so you're making the decision that this is, once you went back to pay, you would go to Dana White or whoever is controlling it. That's what, I got it. I see what you're trying to...
And Your Honor, if you go to page 7 of my petition.
Okay, hold on. I got
have
it.
you
No,
move
no, I
around
have it
too
all
much.
here. Don't-
Okay.
It's important. I worked really hard. I understand. Page 7. I have it.
Okay, at the bottom there, I cited the 467.070,
Yes.
and I also cited 467.80,
080.
subsection 1, so the court has perspective. That's talking about the jurisdiction the commission has for people, which is that they may issue and revoke licenses. So, which is consistent with all the other statutes that we just stood up here and talked about, saying that that all contestants must be licensed by the commission. Everything requires licensure. To stand up here and try and misdirect this court to say, oh, we have jurisdiction over somebody not licensed by the commission, these have failed to point to any statute or regulation saying that. Especially in the light of those 2 statutes that they violated Mr. Silva under, which says you must be licensed. Now, before I sit down, I think it rises and falls with the jurisdictional argument, Your Honor, but if the court's inclined not to find that they violated that statute.
If you want to add anything to your next section, it's kind of like when you're doing a closing argument to a jury. You don't know what they're going to do. I have no problem with you doing. I apologize. I had a 10 o'clock. Are you okay, Mr. Young?
I'm fine, thank you.
Okay, they're fine. I'm
I'll
helping
just
them on
need a
a
few more
trial
minutes.
date, so no, you're,
I'll just keep a few more minutes, Your Honor.
they're okay. That's fine.
I think
No, it's important to, I fully understand that. Believe me, I understand it.
I think the court has to understand that the minutes of the court was questioning whether or not you should consider was the only
Yes.
thing I had, so I put
I
that in
know,
the record. So,
and honestly,
and those were, and it's unrebutted, and those were 9 to 12 month suspensions for performance enhancing drugs. It's important to keep in mind that the acknowledgement of diuretics, even though it's a prohibited substance, is a non-performance enhancing drug. So to suggest that,
now how would I know that? What's in
It's
my-
outside
Is
the
that- let me ask, okay? That's my concern. I know what diuretics do, quite obvious, but see, but once again, and I agree with you, Mr. Goodman, when you said it, but that is, I looked, I know what diuretics are, and I heard his explanation and inflammation, but that's outside what I could look at too.
and so.
And I know it's frustrating. I know it's frustrating for the
Well, I
court
think
and
the
everybody,
court
but
can
we're,
take, I mean, if the court knows what it is, I don't think
I
you
know
need judicial notice or something
I-
for record.
but I will tell you, I don't know if it's I don't know if it would enhance a fighter's ability or not. I
Okay.
know they would urinate a lot, if that helps.
Um,
That's what a diuretic does. That's my medical background. Okay.
now-
But you did give me the minutes of 9 to 12 months.
Okay,
Okay, and I understand that, and I did look at that, Mr. Goodman, because you know what I'm looking for.
I know this
For
court,
what I
so,
can.
you know, I appreciate that comment,
Okay.
Your Honor. And so when you look to see whether or not, now this is a standard where you look for arbitrary and capricious.
Right, no,
And so when you look at the disparate treatment, and you have throughout the record, and I cited it at length in my motion about that that Mr. Eccles, quite frankly, was telling the commission that we have to, repeatedly, we have to make a full record here, we have to make a full record. And the chair's concern of, quote, the need to create sentencing guidelines for violation of this performance-enhancing drug program that have a uniform sense of fairness. I think that is an acknowledgement from the commission, Your Honor, that it's all over the board, that they don't have any type of guidelines, that they need to have some sort of reference on what is what. Okay, so you heard from Mr. Eccles, this is the first time that somebody, if it is, which I don't know, because it's not in the record, but if it's the first time that somebody left and didn't submit to a drug test, does that really warrant a career-ending sanction? There's just nothing in the record regarding that, so we would say that weighs in favor of the fact that it's arbitrary and capricious. But again, we would remind this court that that in our view, based on the statutes, Mr. Silva, whether or not he left or he didn't, was not required to submit to a non-consensual drug test. And then, as the court already said, the commission was concerned about the arbitrariness of the amount of the fine by getting reversed from this court by issuing sanctions that were, quote, outside of the norm. And on page 10, I just wanted to highlight, the commissioner said, I don't want to see a headline at some point in time that said this was overturned. One of the ways that we invite this to be overturned is to suggest that if it is too far outside the norm of what we've done in the past, then in fact it could be considered to be arbitrary. So what they've done in the past is sanction people up to 30% of what their purse is on actual violations. Under that statute, right, Your Honor, 467.158, they can't even bring a complaint against Mr. Silva because he's not licensed pursuant to the chapter. So I don't know how there's any evidence that would support an amount of a fine of an imaginary purse. That's why they're caught in this position, because there was no contract, and the court knows there's no contract, because you have the chair of the Nevada Athletic Commission that kept on saying, let's go to Google and see what we can find in the past. That's not reliable evidence, Your Honor, on what somebody earned 3 years ago. So Again, I don't want to go on, Your Honor, but, you know, the
You've given me
NAC,
you've given me the highlights, and I appreciate it, because it is extensive. Yeah, okay.
and again, NAC 467.022, even though it's a code, it does not contradict with the statute. It says before a license to engage in unarmed combat is issued or renewed by the commission. So when the court was asking Mr. Eccles about, hey, when you do licenses and all that, the code says before a license to engage in unarmed combat. So again,
So I understand that.
you know, I'm not going to summarize everything, but the fact that the commission admitted in their findings of fact and conclusions of law that they only have jurisdiction over licensees of unarmed combat is consistent with the two statutes that we contend that they exceeded their violation, requiring licensure as a prerequisite before they can even take a complaint against Mr. Silva. Thank you, Your Honor.
You're welcome. All right.
Your Honor, may I simplify?
Yeah.
Just a few points I promised to be under
That's
the
fine.
minute, I think.
This is your time. Mr. Young's fine. I'm I'm so sorry, but, no, it's,
Thank you, Your Honor. And I just feel I have to take another minute of course time. I appreciate your
that's
time.
fine. It's
My
important.
argument,
I understand that. Please,
My
you're not
argument-
wasting my time. You're helping the court.
I know the
appreciate
court
it.
knows this. My argument is that the commission gets their jurisdiction, their statutory, the jurisdiction from the statutes, which is given to them by the legislature. If there seems to be that there is a regulation that is different somehow from that, the statute controls. The court knows that. I pointed out all the statutes that I believe give the commission this jurisdiction. Mr. Goodman keeps representing that this, you know, this agency is just some kind of licensing body that rubber stamps things or doesn't. No, that's not their function. They don't just give out licenses or revoke licenses. They have control and jurisdiction over all contests to be held in Nevada. So obviously there's a broader scope, and as I've already referenced that NRS 467.108, which as recently as 2011 told them that they must use certain funds to test people out of competition, essentially, Your Honor. They have a mandate to do so.
I see that.
I would point out, nobody's pointed out to the court so far, I don't think, but there is a definition of unarmed combatant as well as contestant. The definition of contestant is found in NRS 467.01.
Slow down. NRS 467.010.
0103.
Is that sub 3?
No, it's just .0103.
.0. Okay, and that's contestant.
Yes, and
Okay, and what about
combatant?
unarmed combatant?
Yes, Your Honor, that's also defined, and it's at NRS 467.0108.
0108.
I have those for the court.
I would appreciate it since I'm an unarmed combatant. Thank you. Okay. That helps.
And
And
so,
that's
Your Honor,
NRS, okay?
yes, you can see that a contestant is included within the definition of an unarmed combatant. NRS 467.0108 sub 2. Unarmed combatant includes without limitation a contestant.
Okay.
Now, finally, they can't admit these facts at a hearing and then come to court and say we didn't admit them. That's what he just did. He came and told the court we didn't have a contract. There was no contract. Well, then why didn't you argue that at the hearing? Look, Your Honor, I already pointed out, page 35 of the record, lines 6 through 7. Silva contracted with the UFC to participate in a professional mixed martial arts contest against Chael Sonnen at
You're
UFC
talking about
175.
the
Yes, Your
compliance.
Honor.
Yes,
And
okay.
he admitted that. And so it's not just part of the order that was drafted and signed by the commission. It's not just part of that. It was something that they specifically admitted and waived the right to have an evidentiary hearing on. So I'm not making that up or putting it in a minute. It is part of the record, and it's substantial evidence to show that he was a contestant. And again, lines 20 through 21, at the time Silva was ordered to provide urine and blood specimens for testing, he knew that he was a contestant
I see.
at UFC 175. He has the status of a contestant. We had the ability to test him for the health and safety. And again, to be held, the jurisdiction of to be held contemplates things in the future. That 108 statute 467.108, they have a mandate. They must use certain funds to do testing out of competition against, out of competition testing of unarmed combatants. We have that definition. Contestants are unarmed combatants. He's admitted that he was a contestant. And so, Your Honor, I guess, as a public policy argument, finally, in closing, you've got two sides, and probably often happens, two sides are both saying this is clear. I'm saying it's clear because we have statutory authority. These regs can't conflict in any way with that. He's trying to say the regs control. That's not the case. We're just saying the statutes control, and we can see that in the statutes. We have this authority, not just over licensing, but over contests to be conducted. Over all these contests, they have sole and original jurisdiction over these things. And so again, you have two sides saying that, hey, my side is clear. Well, Your Honor, if the court does find an ambiguity, I would stress that there is a public protective purpose in here, and that obviously I've already talked about it. These guys are throwing strikes intended to inflict injury on an opponent. That is, the very definition of this sport. And so there's a protective purpose, the health and safety of these combatants that the commission is trying to ensure in doing this type of out-of-competition testing. And I think that there is substantial case law over the history of this court and the Nevada Supreme Court that says, hey, if there's a public protective purpose to these things and there's an ambiguity, such ambiguity should be resolved in favor of the public protective purpose, and it should be construed liberally. And if there is a conflict, you have to read these things together to find reasonable results. And given all the statutes I've cited, this is a reasonable result, that they have the ability to test unarmed combatants and contestants, and they have admitted again that he was a contestant for this UFC card in Nevada. And given all those things, I feel that the balance is in favor of the state here. The commission, we wouldn't give them the time of day. The record doesn't reflect that, Your Honor. They asked multiple times, do you want to file an answer?
Well, see, and I have to look at the record. I understand comments like that, and I'm sure Mr. Goodman was frustrated. I'm sure you're, does that make sense? I'm looking at the record on, I'm looking at what I have here, and I know it's statutory construction, so comments like that are not something really that would enter this court's necessarily thought process. And do you see what you understand where I'm coming with? I actually understand his frustration. I'm sure you can read through the lines that people were frustrated here. I mean, I could read through the line. You can read the transcript like I have and understand that.
And finally, Your Honor,
yes.
Abhorrent behavior. That's what they called it. That's why they gave the sanction. And
I saw the comment by the chairman, or
and
the unnamed man. I got it here.
Yes, Your Honor. I would finally just add, what is part of the record is this World Anti-Doping Agency's prohibited list for the calendar year 2014 in that case. And as part of that exhibit, I'm not going to argue what a diuretic is or anything, but I'm saying that you can take notice. You can see that diuretics are on that list as substances that are always prohibited.
Right. No,
they are in the same category as steroids, hormone modulators, and other masking agents. So this is a very serious thing that is always prohibited, and as such, and in regard to the Commission's comments, is abhorrent behavior. That explains exactly why they had to send a message here and support it in the record. Thank you, Your Honor.
You're welcome.
Okay, the court, I just want to point out a couple of things. The statute 467.108.
467.108.
Yeah, that you gave, Your Honor, to perform random drug testing. That does nothing to confer jurisdiction on the commission. I know the court has that.
That's okay, but I have read it.
Also, Your Honor, if you one more time, just turn to page 8 of my points and authorities.
Okay.
Mr. Eccles didn't know if anybody defined unarmed combatant. That was, and you can see in my footnote.
I marked your footnote. You did.
I mean, and that was one of the primary issues, even down when I filed a motion to dismiss. And all this acknowledgement that Mr. Silva was a contestant, if you look where it says indeed, quote, all contestants must be licensed. I have that in bold italicized. So again, there's a licensing requirement. We know there's no dispute in the record that Mr. Silva was not licensed. Also, on page 6 of my points and authorities, if you go back, we do have the law talking about subject matter jurisdiction, and he keeps on, Mr. Eccles keeps on talking with these phrases, the balance of whatever is in favor of us, and rules of statutory construction. As the court can see, deference is only afforded to agency actions which do not conflict with clear statutory language.
Right, I have to find an ambiguity, yes.
And we cite the case for that. So when Mr. Eccles wants to argue to this court, hey, the code and regulations don't conflict with with statutes, we agree with that. And we agree that when you look at, when it says a licensee who violates this provision, we agree that that is clear statutory language, that that's what they held that's the code that they held that Mr. Silva violated. Thank you, Your Honor.
You're welcome. Your argument very much helped in giving me the additional. What I'm obviously, I don't like to do this, but Slevnell knows, but I'm going to take this. What I'm going to do is, I don't call it under submission. What I'm doing is I work on it, and then I will come up with an order and paste it on my chamber's calendar so that I have a date for you. Let me think. Give me a few weeks because I have a heavy, so I can make sure. Okay, what I'm going to do is I'm going to place it on my, what I call my chamber's calendar for May 11th, and that gives me a deadline that I know. And if for some reason something happened, if a trial or something, I would let you know, but I want to do it as soon as possible. Everything's fresh in my mind. The only time it's tough is, so I will do it for May 11th. Okay?
Thank you, Your Honor.
You're welcome. I would say if I have
Thank
any, I think you've given me everything I need, and I truly, truly thank both counsel for your participation. I thank you so much.
Thank you very much.
You're very welcome. You are.